Hi, my name is Sarah Chow and I'm a Community Engagement Coordinator with Legal Aid BC. This is the second video on parenting agreements, where we explore more about what the court and the court process looks like when parents cannot agree on their parenting plan. If you haven't yet watched our first video, I encourage you to pause this one and watch that one first, as Shalina Nialani explores how parents may be able to work together over their disagreements. This second video, which explores more about the court and the court process, is of a recording of my conversation with Chandan Sabharwal. Chandan Sabharwal is a lawyer who practices in the area of family law as part of Sabharwal Law Group. She has experience handling cases in both the Supreme Court and the Provincial Court of BC. So let's get to the video. So Shalina has talked about parents working it out on their own or with help from third party. But when those situations do not provide a solution, what might be the option for parents to reach a parenting agreement?
So if they've tried amicably to resolve the issues and they have been unsuccessful, then the next step would be to go and apply to court to get an order in place. Now, you can do this in BC Provincial Court. One party would file what's called an application to obtain an order. And once they've filed that, they have to arrange for personal service of that document on the other party. And the other party will have 30 days to respond. However, in a situation where emergency orders are required, so for example, if one parent is denying parenting time to the other and the parent is unable to see the children, that parent can then make an emergency application so they can bypass that 30 days wait for a response. They can go into court on an emergency urgent application, so litigants to go into court and ask on an urgent basis that they need some sort of a parenting plan put in place until matters can appropriately be set for a hearing. The court is only concerned with what is best for the child. The best interests of the child are paramount. That is the only consideration for the court. And both the Family Law Act and the Divorce Act also state that there should be maximum contact with both parents. So unless there's safety concerns, both parents ought to have the maximum amount of time possible with their children, because that is what is thought to be in the best interest of the child. So that is at the forefront. So you can do this in provincial court. It can also be done in Supreme Court, and that is a bit more of an involved process that counsel can help with. But if that's not the case, there's always duty counsel available at the courthouse that can help navigate the litigants with the forms required. Also, there's Family Law Line, which you can call duty counsel on the phone, who can then guide you through the process in terms of, okay, these are the forms that you require, and all forms that you need to fill out for both Supreme Court and Provincial Court applications are available online on the respective websites of the courts. Click the appropriate form and you would fill it out and take them to the court registry. And you always take 4 copies of everything, because the courts require 4 copies of each document when you're filing it. So that's the starting process for obtaining an interim parenting arrangement order.
So what's the difference between an interim parenting order and like a parenting agreement?
So if you are able to reach a parenting agreement, that can be a final agreement. So you can file that in court, in Supreme Court or in the Provincial Court Registry, and it has the same weight as a final court order. An interim court order is just that. It's interim. It's for the time being. It's to get us through this current time period, whatever that time period may be, until either the parties can resolve the issues between themselves, because that's always a possibility. Even after you go to court and you have some sort of an interim order, you can still negotiate, whether through counsel or getting a mediator involved. After that's done, you can still come up with an arrangement. But if, let's say, you're not able to do so and there is disagreement on what should happen with the children, i.e. one parent says, I want the kids to live with me, and the other parent should only have weekends, and the other side says, well, no, I want to have a shared parenting plan. We can both care for the children on an equal schedule, like, for example, week on, week off. If they can't come to an agreement and the interim order doesn't address that, which it likely wouldn't, then the court would set what's called a trial date. So these are hearing dates where the court, a judge, will hear both sides. They will give their evidence orally on the stand, and they will be cross-examined by the other party or the other party's lawyer, and then the judge makes a decision, a final decision on what should happen. A final order is more difficult to change or vary. We have to show what we call a material change in circumstances in order to change that final order. So it's always better to have a final order, because then that is your status quo. Then there's no ambiguity left.
So it sounds like there could be different options for an individual. So what are some factors to consider when thinking about which option is best?
So I think the biggest option that people should consider is whether or not they're able to communicate effectively. If you're not able to communicate effectively between the two of you, then you won't be able to negotiate. Second thing you should consider is whether or not there's a stalemate, which means, are either of you stuck in a position and you're not willing to compromise? Then that is a problem. Then you need somebody else to make that decision for you, because it gets frustrating for both parties. They become frustrated, and then that impacts the children as well, because they will see through that frustration most of the time, and it has that spillover effect, which isn't good for the kids, and it's not good for the parties either. It doesn't foster a very warm environment. It leads to frustration, anger, and that's not a good place to be. So can you communicate? Are you stuck in your positions, or are you able to compromise? Those are things you need to consider. If you're at that position where you're not able to, communicate effectively, your ability to negotiate will collapse. Also, I think people need to consider whether or not there's a power imbalance in the relationship. So if there is abuse in a relationship, the victim is generally scared because of years of abuse, and they're not in the mindset or the mind frame to negotiate properly, and they might need counsel on their side to speak for them, because it's difficult for them, just because that has been the way for such a long time. They don't know how to get their voice heard. And if that is a circumstance in which someone finds themselves, then they ought to consider getting counsel, because counsel can then speak up for them, and they might need that voice and that support.
Earlier, you mentioned briefly just some of these resources that could be available. What resources would you suggest to individuals needing help as they go through this process?
So I think we're very lucky in British Columbia. We do have resources available. As I've already said, there's legal aid. The legal aid website is great as well. If you just want to get preliminary information, the website is very fulsome and wholesome. You can read up about different areas of family law and sort of get yourself familiarized with the issues. Then there's duty counsel at the various courthouses that you can consult, and they're all experienced duty counsel. We're very lucky to have that. And the other resource I spoke about was the Family Duty Council, where you can call duty counsel. So people in remote areas, they don't have, for example, Surrey, we have duty counsel. Probably they're more accessible because it is such a busy registry. Whereas somewhere up north in more remote areas of British Columbia, Provincial Court doesn't sit every day. Duty counsel isn't at the courthouse. Then you have a resource such as Family Law Line where they can pick up the phone and call in and speak to a duty counsel over the telephone. So they can at least get the steps and the initial information, initial steps to get them started. Because knowledge is power. The more you know, the more confident you'll feel as a litigant to proceed with the matter. So these are really, really good resources. And then there's support workers throughout British Columbia. There's various agencies that can assist throughout, right? For example, in Surrey, we have Surrey Women's Center, a great resource. So there's a lot of resources out there. It's just a matter of being pointed towards the right ones. So duty counsel, I think, is a great resource. And legal aid, apply for legal aid for people with low income. It's a good place because then if you have legal representation, at least your initial steps are guided with counsel and being represented by counsel.
Thank you. That's really helpful.